Okay, so hey, I'm Bridget Lynn Dolgoff, Carrying Stones and Digging Holes, weekly talk. And today we have Ken Dost third class, birth certificates. And so we're going to roll. So
we're going to modify that a little bit. We're going to talk contracts first before we go into birth certificates because it segues right into it.
Okay, yep, no worries. I'm just keeping with the program. All right, does anybody have any actual, does anyone have any questions? And I'm going to turn my video off too to kind of speed things up. Does anybody have any questions for Ken from last week's information?
And last week we talked about the name and how the name, how the all caps name and how is inexplicably linked to the upper lowercase name.
Okay, so Somos,
and hopefully,
yeah, so Somos raised his hand or raised its hand. I don't know if it's a girl or a guy.
Thomas.
Yeah.
No, Thomas.
Hi, Ken. Thank you so much for the invite.
Hey, Thomas, how you doing?
Good, my friend. Thank you. Thank you for all you do. My question isn't really about last week. I've been going through the entire transcript from YouTube, and I've been in the process of condensing it down. I started off with 100 pages this morning. I'm down to 42, so hopefully I'm going to have that done real quick. I don't know if you're aware of it or not, but when you post anything on YouTube, you can actually grab the transcript with the time-stamped marks on it and actually print it out. You've got to do a lot of copy, cut, and paste, or so that's what I've been doing on the May 2nd YouTube thing. The other statement I wanted to make, did you have a chance to see what I sent you regarding the Mason's Manual?
I read it. I haven't had a chance to go through it in detail though, but yeah, I did look it over. I'm going to look it over probably here when I get to it this evening and go through it in more detail and give it a gander.
Basically what it is in a real quick nutshell, every state legislature in 45 states has what's called a source book. In that source book, it's called the Mason's Manual, and that's the legislative rules, the legislative procedures for each state. Oregon uses Mason's Manual, California, Arizona, Florida, Texas, a whole bunch of states. But anyway, in that specific section there that I sent you, section 73, it says the people of each state are fully vested with sovereign authority expressed by their elected representatives serving the legislature. What we found out that in order for us to get any remedy, we need to go into a court of justice, which is the legislature, not a court of law. So with that, I will go ahead and mute myself. I just wanted to share that with you verbally, okay?
Well, I agree with you. It is legislative, absolutely. Now, as far as going into a court of law, I think that what I'm doing here bypasses all of that and takes it strictly to an administrative level. And also, too, when we talk about states, we're 50 states under one constitution. The problem with it is because they've fractionalized us and sliced us up into all these different pieces, they've got us running through all different jurisdictions. So we're not, it's one thing to say that I'm in Oregon and I'm in Oregon's jurisdiction, but I'm really not. There really is no jurisdiction because they're securitizing me through and securitizing all of us through the state of New York. They're taking us into the Admiralty Maritime through, of course, the Commonwealth states. Most predominantly is Virginia, and Texas has laundering us up through Canada. California is laundering through all the technologies through Silicon Valley. So, I mean, there's really no jurisdiction to speak of. And so in that respect, it's really a moot point to battle on a state level because you've got all these other jurisdictions that are involved in this. So in other words, even if you won a case in Oregon, for instance, where I'm at, it would matter little because of all the other slices that are out there. And that's the problem. That's what we've got to realize that these are not state issues. These are legislative issues, most definitely, but not at a state level, at the federal level. And so that's where we've got to concentrate all our efforts because that's the hub, the federal level at the United States Patents and Trademarks Office. As I'm hoping you're starting to see what they're doing with the name, that is really where all this stuff emanates from, and that's where we've got to kill it.
Well, in that section,
any other questions?
I have It looks like
Thank you.
Marjorie's raised her hand to talk. So Marjorie, will you?
Hey, Ken. In researching today, I came across Breckenridge Property something 2016 LLC that appears to be buying up properties all across the U.S. Have you run across that name at all?
I haven't run across that name, but I'll certainly check it out and see. And it very well may be. And it very well, and this is what they do anyhow. They're constantly creating new LLCs to consolidate new companies into, or I'm sorry, new properties into. So yeah, that wouldn't surprise me. I'll look it up. Breckenridge, you said?
Yeah, I'll send you a screenshot later. Thanks.
Okay.
That's okay.
Okay. Yeah. If you can. Yeah, if you can, please, because this, and you'll see as we go through this, you'll see how they're doing all these contracts within patents and trademarks. And that's exactly the problem. What we have is we've got these, our enemy here, as far as I'm concerned, it's not so much the government. The government needs to be educated, because I believe the government is really outside of the upper echelon that really know what's going on, which is very minimal. The government, by and large, they're incompetent. They've been deceived just as much as you and I have. And so we've got to educate the government as well. And everything, again, stems from these automated processes that originate out of patents and trademarks. And that's what we're going to get into today, is walk through a couple of these contracts and illustrate for you how they, actually it's the secret sauce, really. What we're going to talk about today, I'm going to show you today, is exactly what they've done to pigeonhole us into this enslavement that they got us into through contracts and through hidden contracts, and it all has to do with patents and trademarks. And so, I think most of the people on this call, or not all the people on this call, know that the court system really is ineffective, is a rigged system, and it is. There's nothing we can do by way of the court. You've got, in order for there to be any kind of justice, there's got to be some basis of fact involved. There's no fact. That's the problem. The problem is that they're sticking by, they being the court, and of course these foreclosure mill attorneys, that you signed this document. Here's your signature, and that you defaulted on a mortgage loan. Well, what you're going to see today is that we're not talking about mortgage loans and real property. We're talking about mortgages in trade name and in patents and trademarks. And that's what we're talking about here. And for those reasons, the court doesn't even really have jurisdiction in these matters. It's the wrong court. We should be in patent law, in the patent and trademark law, in those proceedings, not in the civil law that we're involved with now. And number one. And number two is that you can't have any justice when the conversation is a lie, when the basis of these contracts is purporting a lie and a deception, which is that these are mortgage loans to real property. And when you can't, and when you cannot bring the material, the evidence forward in court, when they will not allow you to present this in court, then where is there any justice? There is none. So we've got to bypass the court system. And you've heard the expression competent jurisdiction. Well, who's the court of competent jurisdiction? At the end of the day, it's you and I. It's each one of us individually, by taking back our rights and simply just putting these names together and merging these names together. And by doing so in patents and trademarks, which is what we talked about last week with the names, by doing so, what we're doing is we're eliminating all those intermediaries. And there's a lot of intermediaries in there. We've got all these attorneys in there, their whole attorney network that is networked together through these agreements and patents and trademarks. And this is where we've got to cut this stuff off at, is there. So if there's no other questions.
Yeah, hold on, Ken. I'm backed up here. I've got to back up. So Par wanted to speak on some observations he's making. Okay.
Well,
okay.
Hi, Ken. It's in regards. I follow some, and as do Bridget of the common law and other researchers. There's some guys in Australia, they've been in it for, I think, maybe 10, 15 years, and they specialize in language styles manuals In Swedish,
Okay.
I would understand what standard is, because we have standard is also the same as when you make a march, you will have someone in the front holding actually arms or a flag or something. So that's actually a standard. That's actually a French Latin word. But the standing in court is also ruled by standard language. And the language styles
Yeah.
manual from the universities that are in use for law has to be copyrighted and in service or in print. They have special definitions that's quite keen on separating large and small letters. Well, capital letters, anything written in all caps is not language understandable according to them. It's akin to sign or sign language as for a deaf person talking. So anything that's written in
I've
large
heard that
letters,
before. Yeah. Okay.
yeah. So that's kind of, because lots of things you showed last week, if we would screen into things that were written in all caps, that would be mute according to contractual the contractual side of what's implied. So, well, it's just an observation. So I just want to put it
Well,
in.
it's yeah, but see, but you're all, but well, but yeah, on that note, you see though that with the examples that were shown last week, that obviously they're using the all capitalized name. Obviously, there's an important point to that, it is the basis for what is forming these corporations or is incorporating us into these contracts, because that's the non-human. And that's the separation, the intermediary between us, the living individual, and that all capitalized name is the attorney. So, I mean, the predominant focus here is the all capitalized name. I hear what you're saying. I've heard that before. But we're also talking, you've got different bodies of law, different rules and different definitions under certain jurisdictions and legal legalities, jurisdiction. You get into patent law. I mean, the language in patent law and trademark law is entirely different than it is within civil law, and within copyright law as well. And also too, within copyright law, we're talking about computer codes as well, and syntax and XML and all these different languages.
So
and that's how they're operating. I can only go on how they're operating. What you're saying, I hear what you're saying, but how they're operating is directly opposite.
Let me put the finger again on, because a lot of the text you were reading, a lot of text, and many things were written in large capital, not the names, but other parts of it, and like logical reasonings, contractual sides of things, and everything of those things. And suddenly it's all in all caps in the styles manual. That would be like, that's a separate language. It's not English. It's not understandable. It's like mute. It means nothing. So if you actually would go back, and we saw the text you referenced last week, and anytime it came like capital letters written as words, as we would normally try to think about,
so
it would actually say nothing.
Yeah,
well,
I understand kind of.
But also though too. But hold on a second, Bridget. But also too, what we're talking about language here. But what we should be talking about, if we're going to go to talk about languages, then we might as well go to the syntax that they're using, the XML, and I can show you all of the WC3s. WC3 or W3C, all the computer languages that these are being transcribed into. That really blows everything out of the water then.
Well, and also, another thing too is that, if you try to approach a court or whatever, your city or state, at least in the United States, with, documentation that said, hey, look, I don't really understand what's on this document because you put most of it in all caps, you get like zero response. And so a lot of the things that are being done, and the other thing too is like they've created, I mean, you have banking. I bought a dictionary at the thrift store last week because I wanted to prove a point, but I forgot it. And it's on the definitions of wood. Do you know that there are 10,000 definitions in that one dictionary on wood? So every time you have like the legal system, they're talking in a different language, the economic system's talking in a different language, but somehow they're actually communicating
It's
together.
the context that you're talking in.
And at the level that they're communicating together is the copyright,
Yes.
patents, and trades, right? So you could break apart their contract
Well,
or how they're
and you talk
talking about things, but the bottom line is
right. Well,
you're
it's
not
the,
going to
it's the
debate it.
application of the words too. Like
You're not going to debate it with, so you're not going to debate it with the Copyright Patent and Trade Office. So you're not going to say, look, I'm breaking apart this whole thing. I see that you're trafficking, you know, my copyrighted name. And they'll just look at you, you know, like you're crazy. So, you know, we're kind of moving away from this whole, this is what I had to do in order to work with what Ken's has, because, you know, it's exceptional. Nobody else is doing what he's doing. So, and I know that because I know a lot of common law people, nationally, internationally, is I have to get away from the whole common law perspective because it actually also is trying to give me a lot of information so that I can go in and battle and try to prove my point or who's right or wrong. And none of that works. I've been on, you know, I've been in some really extreme situations and none of it has actually worked. I have documents that I use that are syntax documents. That's kind of like how I get around in the world. I haven't actually extricated myself. But what Ken's offering is that you don't have to prove to anyone anything, and you just go to the Patent, Copyright, and Trademark Office and say, look, you people, I don't know if you're aware of this, but I'm disputing the person who is using or who has authorized or who's signing for the usages of my name in this particular matter, patents, trademarks, and copyrights. And I'm just notifying you that legally that you have to give me back because I can prove that I am that person. And so they will actually give you those documents back. So then it trumps everything. And this is the most beneficial thing of all that I don't think anyone's grasped is we don't have to walk away from our federal trade accounts. We don't have to walk away from the hedge funds that they've built on us for, I mean, even signing for an AT&T contract for a phone gets them a $30 million bond on you and a life insurance policy. They want you to not pay your bill so that they can actually collect on everything that they have built up to that so far.
Right, they want to instigate a default is what they want to do.
So they can, you know, scrape up their what they've created behind the closed door that you don't know. So once you go and you start dealing with them and you start getting your copy, trademark, and patents back under, because you're just notifying them. It's not a big battle.
Yeah.
You don't have to write an 80-page document and you have to prove language and how this is used or that's used. We're just going far way above that. And we're going to a business office that deals with this. And if there's the dispute, they actually will correct it. And then you have the documents that prove that you are who you are on an economic level. So you don't have to walk away from anything. You don't have to decide to expatriate or, you know, be a sovereign. You don't have to actually extricate yourself out of the system. But yet then you have full control, because anytime you have a problem, you just send them the correction change of the copyright, trademark, and patent document, and you know, there you go. You're not going to pay for a ticket. You're not going to pay for a lot of this stuff because they're going to see that you have the original economic, fiscal documents, the bonds, the contracts, the hedge funds, all of the bank accounts. Now you own. Everything's been trading on that. So, I mean,
good job. Nicely said, Bridget.
I listen, Ken.
Yep.
All right. So that's, you know, I'm just
yeah, good job. No, you're doing good. I could go have a cigarette. You're doing great.
Well, I just want to, you know, it took me a while to kind of understand this, you know, like in a full circle, because I kept trying to look for stuff that I could use to battle, or
Mhm.
say, hey, look, I found this, and this says this and this, and you're using this and this wrong, and I want this, that, or the other thing. And then you don't get a response, or then you get attacked, or whatever it's going to be, where you don't have to
Right.
do any of
Right.
that anymore. We're not going to the legislature. We're not going to the courts. We're not going to any of those people. We are going to the Copy, Patent, and Trade Office, and then we're going to the United States Trust and negotiate our payout.
Yes. Yes.
That's what we're
Yeah, because what
doing.
you're doing is all this is. This is all business. That's all it is. You stole my prize-winning pig and its DNA and its RNA and all the offspring, and I want it back. And we have reversionary rights of interest there. And this is within patents and trademarks. And so, like I said last week, what they're doing, what the banks are doing, what these attorneys are doing in these mortgage loans and in anything, is they're doing an assignment. They've attached you, they've connected your name to a customer list, to an accounts list, to a list of warehouse list. And they're securitizing those things, and they're selling them in the market. And so what they're doing, and of course these are all trademark goods, and these are patented goods, the automated processes that underlie these things. And what they're doing is they're instructing in their assignments, instructing the Commissioner of Patents and Trademarks to look, we got some static somewhere. And this and this and this. What they're doing is they're going to the Commissioner of Patents and Trademarks within these assignments, and they're instructing the Commissioner of Patents and Trademarks, and they're acknowledging that, yes, that the grantor is the owner of all rights, title, and interest, sole beneficiary of all these things, but for the fact, which is not the fact, but for the presumption that you gave them, that you pledged to all rights, title, and interest over to them. And that's really what this comes down to. And so all we're doing is we're coming back in the Commissioner of Patents and Trademarks and say, no, wait a minute, I revoked that. I did not give that permission. I did not voluntarily agree to pledge all my rights, title, and interest to these attorneys or to a nominated agent. And I instruct the Commissioner of Patents and Trademarks to make this correction. And they have to make it. Why? Because you don't have to argue about constitutional rights or anything. All you got to do is instruct them, because we've already got them on violations of our constitutional rights, because, and this is prima facie, based on the fact that all of the attorneys, foreign agents that have no loyalty to this country, or have their only loyalty is to the Queen and Parliament, and so that's treason to begin with. So when we go and instruct the Commissioner of Patents and Trademarks, he's got to make the correction for us.
Another thing too is that, they're imposters, and we can prove that by just sending a letter saying, hey, I'm in question of this.
Yes.
And I would like to correct it. And so then once they go in, then they're like, oh, well, somebody's imposter. They're an imposter in your place. So that's not a good thing. So we're going to rule on your side, because, we can't have you disputing it and then have, because they have to make a very correct record, right? That's what that's what they have to do.
Understand what we're talking about here is we're talking about a very confined trade secret here. This is the trade secret. This is the trade secret of everything. It really is, because and as you understand patents and trademarks more, and as you start becoming more familiar with them, I'm sure Bridget sees it now too, is this really is, the patents and trademarks is the model for everything. I mean, it is, everything comes out of there. And that's where the control point is. So this, what we're talking about here, and these agreements, and taking back these agreements or revoking these agreements, is absolutely huge. I mean, it's huge. I mean, the ramifications of this are immense, because it's on a global basis. And you'll see that as you go through these.
Hey, Ken.
Yes, ma'am.
So there's just a couple of things that I want to, before we go into the class, I think Somos wants to talk again, but also I just want to say there was a question or kind of a statement in regards to, and we're going to know what to do as we go along in the classes, right? So number one, we'll find out if, who help you to figure out maybe, who you would apply to in Canada for patents, copies, and trademarks, but I bet you anything that England and the US have their finger in it to some extent, because there has to be international contracts and trades. But anyway,
It's
So,
all international. I mean, you can't
yeah.
look at it as a United States thing. Look at the global map as a big corporation.
So, but we'll come back.
And-
Yeah, we'll come back to that. And then the other thing too was that somebody had a question about what do they do if their name is already patent. But we're going to go towards that as we go through the classes, right? So today we're
Yes,
just
yeah.
so Somos, do you want to talk real quick and then we'll get on to the class? I'm the butcher. I'm like the machete cutting through the red tape here. So, all right.
I'm
So,
trying to follow proper protocol here and raise my hand. I've been on a lot of Zoom calls where it's every man for himself. But Ken, would you classify this as the hybrid of merging the legal and equitable title without going into probate court and
Yes,
demanding
yes,
based upon
yes, absolutely.
Okay, so you know what the process of letters of administration
Yes.
under DE 150 and the DE 140 under California probate law. So basically what you're doing in regards to a mortgage, you have a right to file what's called a notice to preserve interest with a 1099-S. Now what happens is when it comes up for the big roundup, you don't take it into their maritime marketplace courts. You take it into probate court to go ahead and merge a legal and equitable title, put it into a successor trust, and then assign the reversionary interest over to the Treasury Department and take over the seniorage rights on all the proceeds, fixtures, proceeds, assets, and goods underneath a Treasury account, as you've assigned all the benefits under 95B of the United States codes to reduce the national debt. Is that what I'm reading from you, brother?
no.
Yes.
Sort of, but no.
This is a shortcut to that. But now in respect to that, though, hold on a second. In respect to that, though, until you correct the name, until you give yourself existence, and that can only be done in trademarks by merging those names together. Is absolutely, it's really the long way about doing this. But yeah,
one of the other things,
you are kind of
Ken's cutting out a little bit.
bypassing probate patents and trademarks. Go
So
ahead.
the other thing too is that
Oh, am I? Sorry.
Yeah, it's all right. No,
Am I there?
I'm doing everything I can to keep you from your voice stretching out. So, but your video's kind of locked up, so you may want to turn the video
Okay,
off.
here, let me stop my video then. So
There, that'll help him get.
okay, I just stopped my video. Yeah, I just did.
Okay, now,
yeah, so you don't have to look at my ugly mug. Go ahead, Bridget.
well, I mean, the thing is too, is I suspect, once Ken's process is done, then you can just go to the United States Treasury. You're not going to have to like move money around and do this and do that and do all this other stuff.
Well, here it automatically
pretty cut and dry.
Automatically go. Hold on. Stop right there, Bridget. Automatically, when you make a claim within patents and trademarks and you make this merger by patent law and trademark law, it automatically must be through customs, U.S. Customs must be sent over to Treasury for a full and complete audit, which is good. That's exactly what we want, because now what you have here is all these hidden accounts, all these hidden businesses that we can't get to from the courts or from any other direction. We can get to from here through patents and trademarks, because that's where we come at, that's the import and export aspect of this thing, and that's where we bring ourselves back onto land. This is all done within that audit that we're stimulating, of course, by making these filings within patents and trademarks. So we're basically calling bullshit on the whole system, but we're also saying too that we want to balance the books, and we're also saying too that we're bringing ourselves back onto land and we're exiting commerce. So these are all the things that are triggered by what we're doing that stimulates this audit. And the beautiful thing about this audit is this is where the legal aspects will come into play. This is where you're going to get your legal standing to be able to sue these guys, and where they lose their immunities. Because what you're doing is when you report the trademarks, you're coming in as I'm coming in as Kenneth W. Dost, the body of living matter. Okay, the other part that's connected to me, that all capitalized name, is sitting in that collective membership. for anybody else to use. And they have been using it time over again by rehypothecation and everything. But by coming in as Kenneth W. Dost, and I'm signing that as such within patents and trademarks, which, by the way, in trademarks, the signature is a / Kenneth W. Dost, upper lowercase /. That's how you represent yourself. That's the living individual that claims that all caps name. Now what I've done is I've eliminated all the intermediaries between there. So what's the benefit of that? Well, the benefit of that is now that I put that back together, now I do have standing. Now I can demand that Treasury do a full audit, and I've given a clear because by taking absolute ownership of these things, now I have the rights. Now there's no intermediaries to prevent any kind of audit or any kind of criminal investigation or any kind of investigation from being done, because now I have my authority to basically order Treasury to go ahead and go after these guys. And this is how we're going to start. This is how we're going to stop the bleeding of all these assets and the gutting of America, the gutting of Sweden, the gutting of Australia, the gutting of all countries, is by taking back our rights, and so that we allow the authorities to come in and actually audit these things. And that's what I'm excited for. I want to see Treasury. I want to see Department of Justice. I want to see them come in and start auditing these patents. Because when they start auditing these things, that's when these attorneys are going to start falling by the wayside. Because there's a lot of criminal crap taking place in there that we can't get to right now until we give ourselves a standing. I'm sorry, go ahead.
Ken, real quick. Under Florida statutes, that's where the event and issue took place for myself. Back when we were talking with RB before he passed, 2015, 2016, we focused on this revocation of assumed presumed power of attorney, and we found out that this was really a solid death knell to them, because underneath each state has a termination or suspension of power of attorneys and or agents' authorities. And until you exercise a proper revocation of assumed presumed power of attorney, as it's called for in this section on 709.2109, the guardian ad litem takes place, and the conclusive presumption is you're incompetent to handle your own affairs based upon the fact you've never come forward and you've never properly placed yourself into the body of the living matter. Now, in this section, it's really interesting. It states the termination or suspension of power of attorney or agent's authority. A power of attorney terminates when, number D or item D, the principal revokes the power of attorney. It's right there in black letters on white acres. So
yes.
Okay, so
yes. Now and that's exactly what you're doing here. It's exactly what you do. But here's the problem. I've done that in the state of Oregon. You know what? It got ignored. And it gets ignored because you've got all these powers of attorney that are outside of jurisdiction that are really controlling things. Where does all this stuff come from? Where's all the stuff that come, all the things you're dealing with in Florida, all the things that people are dealing with in Texas or wherever else is emanating from one place, and that's from patents and trademarks, where this all originated from. So when a foreclosure takes place and they get their summary judgment, HSBC and attorneys get their summary judgment, what they're doing is, yes, they're making a filing with probate court, but they're also going to patents and trademarks as your personal representative, and they're saying, oh, I can't find Kenneth W. Dost, or Kenneth W. Dost is incompetent, or he can't be found. And I'm here as his personal representative. He's abandoned his property, and here I'm putting my signature on to clean out his estate. That's exactly what they're doing. So they're going back to the source.
But the thing is, in common law, I've done a lot of this stuff. I've battled the states. I've been through some pretty heavy stuff. But the thing is like, that's lower. We're going, more on the international battlefield, which is copyrights, trademarks, and patents. The other thing is, you got to
cut the head of the beast off.
Yeah. So the other thing too, so none of this lower stuff will matter. But the other thing too is that we're going after the money creation, because they created it off of us. I'm the original deposit the moment I took my first breath, and they've never allowed my family or anyone else on this planet, including me, to access that value. So the thing is, we're going to them and we're going to say, look, you're in violation because you're impersonating it, and these people are standing as an imposter to me, and so I'm just notifying you, and I want you to make that legal correction. And then once you have that information, then now you hold the money. So if you want to,
Well-
you don't have to worry about this whole power of attorney thing anymore, because if anyone sends you a
No, because
document for
by-
any reason, shape or form, from this point on, once you have that document, you just send them a copy of that document and it says, oh, they're no longer the bank holder. Oh, crud, you're the bank holder. That's what it says. I hold the money. And then they're going to listen to you, but they're not going to listen to you when they're just like creaming out your accounts. They don't really care what kind of paperwork you throw at them. Nothing is going to help. You have to go take the money. You got to take yourself back.
Yes.
And then once you have that, then you
Yeah,
just
you gotta take it
let
to
you
the-
notify
You gotta
them.
take it to, you gotta take it to the point of origin on these guys. You gotta remember something. Everything is automated processes, everything. The way government is run, the way that these state legislatures are run, the counties, the judicial system, it's all run by automated patent processes who are engineered by whom? Business of banking, and of course by foreign agent intellectual property law firms. And so what they're doing, of course, they're the enemies of freedoms and liberties. They have no adherence to the Constitution. They have no adherence to or any kind of allegiance to you or I. Their allegiance is elsewhere. So what they've done is they fixed this system to where they can pop in to any agency, make any kind of change as your power of attorney, and nobody even knows it. Nobody knows any the wiser. You know. So and of course what they've done they turned government against us by what? Putting them in the revenue streams, by giving them incentives, by giving them awards, by giving judges and annuities that really belong to us. So I mean, they've corrupted the government, and they turned the government against us. Because what are we seen as? We're seen as incompetent. We're seen as deadbeats, liars, and cheats. You know, so in these respects, what we're doing here by taking the actions that we're taking, we're reversing everything back. And not only does it expose that, but what it's going to start doing is it's going to start exposing the government employees, and they're going to think, wait a second, there's something's going on here. The government is going to realize that they're either complicit, well, they're complicit with this, but they're complicit because they've been deceived as well. And how? By all these computerized patented processes. So to undermine these things, we got to go right to the hub. And we got to look after ourselves. You know, we spend a lot of time in the court. We spend a lot of time doing this and doing that and fighting everybody else. Let's stop fighting everybody and let's just address ourselves and just say, okay, this is what I need to do. All I got to do is correct myself. Once I correct myself, then everything else falls in line. And that's the beauty of this. This is the secret sauce on everything. And this is not applied just to the United States. This is in every country because, like I said, this is not a United States issue. This is a global issue.
Okay, so
and
now,
so it's the same everywhere. It's
now,
just, and everybody's always good.
If I may, real
all
quick.
right, so nope, we're going to go to the class, right? We're just going to go to the class because we have a lot of other people that are, you know, going to want to go over these documents. We just want to make sure we get through all of them today.
Okay, open up Bank Boston Class 3, please.
Okay.
Let's go through a contract. So let's go through a contract.
Yeah.
Bank Boston, yes, that one right there. This was a contract. This is what they've done to us. This should pretty clearly put things into a clear alignment in your mind.
So somebody's talking on their phone. So could you mute, please? Yeah, that would be great. Thank you.
Okay, sorry about that.
Okay. All right. Go ahead, Ken.
Okay, this is a patent. This is a page down just a little bit. This is a reconveyance agreement. Okay, this was done. This is between Bank Boston, National Association. You got page down, Bridget, or page up?
Okay, sorry.
No, page down.
I'm multitasking.
Okay, and that's Fletcher Terry Company. Keep going. Keep paging
Okay.
down. And this was in 1999, I believe. Keep going.
Okay.
Keep going. Keep going. Keep going. Those are the patent numbers. Keep going, though.
All right.
Keep
How far?
going.
Like all the way to the end, or?
Keep going.
All right. Somebody else.
Just keep going. Just keep
Somebody
going. I'll
else
tell you
is
when.
talking. Please mute. All right. Keep going.
Now see what it says. Stop there. See what it says.
Okay.
The Fletcher Terry Company. Up, page down again. You went too far.
I went too far.
Smack.
Okay, here.
No, go.
Up more?
Go back. Yeah, back where you were. Up to the. Keep going.
Okay. Okay, I can hear somebody's door buzzing. Could you mute, please?
Okay, you can stop there. Stop
Okay.
at that point. We'll come back to that point later. Go back to,
Okay.
stop at that point. Go back to that point
What point? You're not giving me a very good
where you were just
direction.
at.
Okay, so go back
Go to
halfway
the
up.
agreement itself.
All right, let me
Yep.
see.
Go back, keep going, keep going, keep going,
Okay, hold on.
keep going.
Okay.
Where I have everything highlighted. Keep
I don't
going.
know. Oh, we had everything
Okay,
highlighted.
keep going. Almost there.
All right. I'm
You're
having
almost
trouble.
there. Not too far. Okay, stop there.
All
No,
right.
no, stop right there.
Okay.
Stop right there. See what it says? This is the Fletcher Terry Company estate. You gotta go back down.
Okay.
Here, wait a minute. I gotta pull up on my document so I can see, so I can tell you what page exactly to go to. Hold on a second. And we're doing this because my bandwidth stinks on this side.
Yeah, so just tell me. I was having some problems. Things were a little slow because people had video and their microphones on. So now I can focus on the document.
Okay.
So tell me where you want me to
Okay.
go.
I want you to go to page 7. I'm sorry, page 11.
Okay, hold on. Let's see. This one doesn't show the pages, so I'm just going to have to scroll down. All right.
Well, it should because it's the PDF. It's a reconveyance agreement, letters patent.
Okay, yeah, but I had to put it into a hub blog link, right? So it doesn't have that PDF. I don't have it on my side.
Oh, okay.
So hold on a second. In order to make them shareable, right? I had to.
Okay, that's fine. I got to
Okay.
get better bandwidth.
Oh wait, here we go. We're going. Yeah, that's all right. Hold on, I'm almost there. Now they have numbers. Here we go.
Right
All
there.
right.
Stop right there.
Okay,
Stop right
back
there.
right up there. Right there. Okay, hold on a second. Let me get it. I don't know why it's lagging.
Okay, stop there.
Okay.
Stop there. Stop
All
there.
right.
Stop. Okay, this is a reconveyance agreement made as of September 1999. So this agreement was right after, let's say about 10 months after the State Street versus Signature Financial Group ruling in 1998. That, as I mentioned last week, I think, was the court ruling that automated business methods were patentable. So this was after that ruling, but it was before the enactment of the 2001 UCC 9. So what this agreement says here, it says, now the borrower is this Fletcher Terry Company, and it acknowledges the Fletcher, that company is the borrower, that they are the sole and exclusive owner of the United States patents and patent applications, and any and all corresponding patent applications there too. And then it says, whereas the borrower and the secured party executed, this is the important part, executed a mortgage, assignment, and security agreement, in parentheses, letters patent, mortgage, made this first day of April 1999. Page down a little bit. Whereas by the execution of the mortgage, the borrower assigned, conveyed, and transferred to the secured party its successors and assigns on the terms and conditions set forth in a loan agreement. So a separate agreement from this one, in a loan agreement. Now think of that loan agreement as your Fannie and Freddie mortgage loan that you signed, referred to in the mortgage, as a security for obligations referred to in the mortgage. So it says it's a first lien upon the security interest in all the borrower's right, title, and interest in and to the patent rights, together with all reissues and extensions thereof. And now it says that all claims for damage by reason of past and future infringement. So right now they've given all their rights over to the secured party. It says here, whereas all the obligations, now it's saying that all the obligations have been paid off and secured are performed, and the mortgage has been therefore terminated. So this agreement acknowledges that there's a separate agreement here that's outside of this patent agreement that is a loan agreement. But for that loan agreement, the borrower had to give all their rights, title, and interest into the patents and patent applications. And so that's been done. So they're saying, whereas all the obligations secured by the mortgage have now been fully performed, and the mortgage has therefore been terminated. And then for valuable, and they're giving it back now. So in valuable consideration of the premises, another good and valuable consideration, blah, 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 so on and so forth, the secured party hereby agrees with the borrower as follows. The secured party hereby reconveys to the borrower fully and without reservation, limitation, or condition of any kind whatsoever, all and whatever right, title, and or interest that was or might have been conveyed to the borrower, the secured party under pursuant to the mortgage, in or to the patent rights, collateral, blah, blah, so on and so forth, to the secured party, thereby returning to the borrower to the position and conditions that would have prevailed in respect of the patent rights and the collateral if the mortgage had never taken effect. So, in other words, had the borrower not made this assignment, he's returning into that previous position. So this reconveyance is and shall be binding upon the secured borrower, its successors and the signs, and shall inure. This is what got me onto patents. This is one word right here, this one statement. This is what got me onto the patent research a decade ago or more than that. These words, and shall inure to the benefit of the borrower, its successors and the signs. That word inure is what lured me to the patents, because I pulled the provisional patent years ago. And there was a statement in there that when I read this in the mortgage loan agreement after the economic collapse, I thought, wait a second here, I've seen this language before. And that's what drew me into patents. So what this agreement is saying here, you're saying, well, okay, this is nothing to do with us because it's a business. And you're right, it is a business. But what the important part of this is, if you could page back up, what they're defining by this mortgage, they're defining by this mortgage as a separate agreement. So you have a loan agreement, but you also have another agreement that is the agreeing by the borrower to give over all rights, title, and interest to the patent applications. Now, fast forward to 2001, when the UCC 9 took effect. When UCC 9 took effect, that means that they were able to securitize our all caps name, or our name and our signature to patented processes. These patented processes are what broke up and decomposed our land or our real property into all different slices. Through these slices, they created separate deeds, all kinds of deeds, deeds of supplementary deeds and complementary deeds and contingent deeds, mobile air rights, water rights, all these different rights they sliced us up into and sold these things off all across the world. And they did this by patent applications and patents. So what they did here was, when we signed that Fannie and Freddie document, what we didn't realize what we were doing was that there's a hidden agreement underneath this one. And if you could please bring up the the MERS agreement, Nations Bank agreement, Bridget.
Okay, hold on one second, please.
And we'll fast forward to what they've done here. So they
So where are we
they
going?
changed.
We're going to.
You're going down to where?
I have
where'd it go?
patent assignment. I have First American Title. I have Boston Bank, Boston, Irish Bank, Esser's
No,
patent.
it's the last email I sent you. There's one other one that I sent you. The MERS Nations Bank agreement.
Okay, so that was from last class, right?
No, well, it should be in your main files. It was I sent it to you to put it in the main files before we started the classes.
Okay, well, I didn't get that memo, so let me go back.
But that's okay.
Let me go back
Okay,
and
okay.
let me go look for it. So go talk about whatever, and then let me go back and look for.
So these other agreements that I'm going to put. So what she's going to pull up is she's going to pull up the MERS Nations Bank agreement. That's the hidden agreement that we didn't know about. That's the agreement that attaches to this so-called loan agreement. That is an agreement in patents and trademarks where we gave all rights, title, and interest to our name to Nations Bank, to MERS as a nominated agent, which they went and took to Nations Bank and gave it off to Nations Bank and put us into this secret system of patents and trademarks. So the important point to understand here is that I think Marjorie's got it. Marjorie's got it attached, and if you could just pick up that one, I think she attached it. I think she picked it up.
Okay.
In the chat.
Yeah, I'm not going to be able. I don't think I'm going to be able to screen share it from there. I don't know. Let me go look.
Okay. So what this MERS Nations Bank agreement is, this is the agreement that took our name and attached it to patented processes. And that's what they're referring to in this Bank Boston contract. They're saying that the borrower here, which is a company, agrees to give all rights, title, and interest. Well, when UCC 9 occurred and they were able to come in and they were able to attach our name to patented processes, to trademarks, to copyrights, but not only that, they were able to fractionalize us and decompose us into different properties. In effect, they converted us to special purpose vehicles. So they created us, they turned us into a company. And that's exactly what we are. We're a company. We're not really a corporation. We're incorporated into corporations, but we're a company. And so what this agreement, this Bank Boston agreement did, it was the precursor to the UCC 9, to where they can come in and say, okay, Kenneth W. Dost is a company now and special purpose vehicle. And through these hidden agreements, he's agreed to give us all rights, title, and interest to his name, to his identity, so that we can attach them to all these patents and all these patented processes and the trademark goods that result from that, to traffic them all over the world, traffic all of us all over the world in all different pieces, parts. And that's the important thing that really is to really grasp on this, is that we're not a whole person. We're not a whole individual. They slice us up in all these pieces and scatter us all around. So what we're doing by going into patents and trademarks, we're going in and we're saying, wait a second here. I'm the body of living matter here, but I'm more than that. I'm a living personality. But in order for me to be a living personality, I have to recognize that all capitalized name, that belongs to me. That is an extension of myself that was abstracted from me. And that would, first of all, would not exist if it was not for my first breath. It's not me, it's somebody else that's impersonating me. And they've sliced me up and they put me all over the country, all over the world, but that's not me. In order for me to be an individual personality, I've got to capture all these things. I've got to get rid of all these intermediaries that have sliced me up and call those things back to me. Does that make sense? You want to open up the, I don't know what the MERS docs 1, 2s, and 3s is. Where the heck is it? You just want the MERS Nations Bank Agreement. It should be in there. Okay, right there. Yeah, that one right there. The MERS Mortgage Electronic Register. Yes, that one there. That should be it, I believe.
Right, it has the 3 documents. That's where I was at. So it actually has more. Oh, wait, here we go.
Go up top, I saw it. No, go up. Okay, yeah, bottom one. There you go.
Okay. Thank you very much. Hold on one moment, please. Okay. Then it has more.
You just want the MERS right there. The MERS Nations Bank, right there. That one right there. That's the one we want.
All right.
This is the hidden agreement that attaches to the Fannie and Freddie document. This is the agreement that was not represented to you, that was intentionally concealed from us by failing to represent the circle R behind the acronym MERS, which identifies a registered service mark or a trademark, which for us is an indication that, hey, this is something I've got to check out for my due diligence. I've got to follow this circle R, because if I follow this circle R, it's going to take me into patents and trademarks, and it's going to give me the source and the origination point for MERS and what MERS is all about. And they intentionally failed to represent that circle R. Because of that, we were left out of the chain of disclosure and representation that this is not a mortgage loan of real property. This is something entirely different, and it goes to the trademark. And if that circle R was represented within the Fannie and Freddie document, we followed that, it would bring us to this agreement. So this agreement is far outside the 4 corners of that mortgage loan agreement. So if you page down a little bit on this thing. And this was done in 6/30 in 1998. So this was done 1 month prior. Get this, 1 month prior to the State Street ruling. So this was done, and of course it was done 3 years. Stop there. This was done 3 years prior to the enactment of the UCC 9. So this was very well set up. Nations Bank, Bank of America, and the entities attached to MERS, which is, of course, Merrill Lynch, Bank of America, HSBC, Wells Fargo, and a whole list of other banking entities and financial services. So they had this whole thing set up. And they had it before UCC 9 was even enacted in the revisions in 2001. They had us trapped within this agreement. And this agreement, what does it say here? It says that this security agreement, as amended, supplemented and modified from time to time. The security agreement is dated June 30th, 1998, between MERS, Delaware Corporation, and Nations Bank. And what they're doing, what MERS is doing, MERS is taking our assets that they captured from us within that Fannie and Freddie document, and they act as our nominated agent, they're going and giving it over to Nations Bank. And Nations Bank is saying, okay, well, we're gonna secure your obligations that you're giving us, but this is where a turnaround happens. We're not the debtor here. We're the borrower. I'm sorry. Reverse that. We're not the debtor here. They're the debtor. They're the borrower, and we're giving them rights and title and interest into our trade name, and it defines all the definitions. If you're going through definitions, page down a little bit, we see the definitions. Go down to trade now, trademarks, if you would, please. Keep going, keep going, keep going, keep going, keep going. Where'd trademarks go? Keep going.
Okay, so page, what page is it on? There's a page.
With the definitions. Back up to definitions.
Okay, so what page is
There's
on the
one
bottom?
for trademarks or trade name.
Okay.
Keep going back up.
Okay.
Back up.
Trademark, this is,
Back.
okay.
You want to be underneath definitions.
Right, yep. All the way back up.
Okay, there's definitions. Now slow back. No, go back down now. Slow down, slowly though. Under defined terms. Keep going. Okay, you got inventory, equipment. Keep going. License. Keep going. Where's trademarks at? Trademarks. There, stop right there. Okay. See what's up? Page back down. You just passed it.
Okay.
Too much.
Too much. That? No.
Nope.
Keep going.
Keep going.
All right.
Keep going. Keep going. Keep going. Stop right there.
Yeah.
Okay. Yeah, stop right there. Yep, stop right there. See what says trademark means all right, title, or interest which the borrower may now or hereafter have in any or all trademarks, trade names. That's the important one right there. Corporate names, company names, business names, fictitious business names, trade styles, service marks, logos, or other sources of business identifiers, prints and labels on which any of the following have appeared or appear. So what they're saying here is our all caps name, Kenneth W. Dost as an all caps name, is an unregistered trade name. It's a protected unregistered trade name underneath international law, underneath the Paris Convention. So what they've done here, what they're defining here, is they're defining an agreement that we gave to MERS as a nominating agent. We gave all of these rights over to MERS to give to the bank in collusion with the bank that gives away our trade name. And of course, what they're doing is they've taken our trade name and they're incorporating it into patent agreements and trademarks agreements. And that's why you see where, if you've seen some of the documents I've done, some of the wordings I've done, I'll say something like all capitalized words and names here and not defined have the meaning as defined within the agreements to and into which it is incorporated. And that's what they've done here. They've taken our trade name, they've attached it to a customer list, into a patented process, or into a trademarks of products and services of say an Aquin, okay? And they've had command over that. So they have our trade name now, so they securitize and resell time and time again, rehypothecate, and they're incorporating us into these agreements as corporations, as single-named LLCs, as different types of conversions in abstract, as business names, and using our big. So all these things they're using here, fictitious business names. So they're creating anything they want to, because in patents they can do that. Because patents are art. Patents is based on a capricious whim. Whatever they can come up with as far as a process is concerned, that's what they're creating. So this is what we gave them rights to. So if you page down further, go down to, well, no, stop right there, don't go anywhere, don't go anywhere. It says UCC. UCC means at the time, blah, 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 so on and so forth. If you go down to the fourth line, they talk about as an effect in a jurisdiction other than Virginia. Okay, well, this is governed by Virginia. They're saying other than Virginia. If we go down to the last page, they'll talk about and say that this is to be this is under the jurisdiction of the Commonwealth of Virginia. Well, excuse me, I never agreed to any kind of jurisdiction underneath the Commonwealth of Virginia when I executed my mortgage loan agreement. I never executed any of this. I never agreed to this agreement at all, and we didn't. And so what this is doing is, if you page down further, go underneath security interest. This defines everything that these patents and trademarks are. Okay, stop right there. So what we've done here, just like that other contract I showed you, it's a grant of security interest, and they're saying here that we granted them. Let's see, here it is. Okay, third line, fourth line. Due and punctual performance of all obligations of the borrower contained in the credit agreement and in other loan documents. What's that other loan document? It's a Fannie and Freddie document, to which it is a party. And in order to induce the bank to enter into the credit agreement and make loans provided for their in accordance, blah, blah, the borrower hereby grants to the bank a security interest in all of the borrower's right, title, and interest to and under the following, whether now existing or hereafter acquired. All receivables, all other intangibles, all equipment, all inventory. And it goes down through this whole list of everything that we've given them a security interest in. So you understand what we've given them. By signing that Fannie and Freddie document, we've executed a hidden agreement by misrepresented MERS as a nominated agent, by false designation, by misleading representations of a mortgage loan and real property that is not a mortgage loan and real property. MERS has nothing to do with real property. MERS has everything to do with delivering us into the hands of evil, which is delivering us right into the secret side of patents and trademarks. Do you see that? Is that, Bridget?
Yep, it's clear to me. Somebody, Somos wanted to, he raised his hand, he had a question, but I was gonna say, all this information, we're holding off questions until the beginning of next class, because Ken has a huge amount. You wanna have the question?
No, not right now. No, I want to go. Let's go through everything here first.
Okay.
But I would like everybody to read this contract, though, and understand what this contract is. You know, what they've done is they've added another intermediary in between, and that intermediary is called a nominated agent. Well, that nominated agent is an attorney. Why is an attorney? Because the attorneys are the ones that are pulling these patents and trademarks. They're the ones that are coming up with these contrived schemes and wealth appreciation schemes and foreclosure schemes and all these things. So we've nominated, and we've literally given ourselves over into an elective dictatorship. Of course, it wasn't elective because it was involuntary because we didn't know about it. And so the basis of going to patents and trademarks and making this correction is very simple. It's very, very simple. It's very clear cut, and it's indisputable. Because first of all, and it's on this contract, it's indisputable. Why? Because it's impossible. It's indisputably impossible for me to voluntarily agree to anything that I have no knowledge of, and especially if it has been intentionally concealed from me. This Merged Nations Bank agreement is absolute prima facie proof that we were deceived into a false transaction for another purpose. And what is the other purpose? To bring us into intellectual properties so that they can attach us to these patents as a company, as a special purpose vehicle by which they have control over us. This is why we can never get anywhere in court. This is why we can never get anywhere without first coming to patents and trademarks and making that correction. Okay, so you really need to read this contract and kind of become familiar with this contract. And if you put in terms of what they've done here, that this all has to do with your all caps name. It all has to do with your identity, with your signature. So this really should inflame everybody, because this really is, this agreement right here strips us of all our freedoms and liberties. It is, our freedoms and liberties are stripped by this very agreement. Okay. Now, if you can open up, let's keep moving on, so we can go to so we can go through these other documents. The other documents I really want to show here. If you can open up the Cashier Pro,
Yep.
I think is the
Hold
one.
on, I got that. Hold on.
Actually, no, not the Cashier Pro. I'm sorry. The First American Title Insurance one.
Okay,
That one. Open up that one if you would.
The First American, and here we go. Hold on one moment, please.
Okay. Okay. This agreement is.
Whoa.
This.
Hold
What
hold
happened?
on. I don't know.
Okay.
I've
This
got all
agreement-
kinds of Zoom problems right now. I don't know why. Hold on.
I try to pick out the best agreements to go through and show you.
Mhm.
There's so many of them. When you understand what the basic concept of what they've done here, you'll be able to follow this no problem, lickety split on a chain of title. The chain of title is not in it's not in the land records of the county. You're not going to find it in the state anywhere. The chain of title is here in patents and trademarks and the agreements thereunder. And it begins, it goes in all different directions. This agreement is an agreement with First American Title Insurance Company, Allied Irish Bank. So what they've done here, this is how they pull us into the union with England and Ireland and England and Scotland, not the union between body and soul, but where they've separated our union, kept us in this union. Now, I've done this through the Palladium venture, through the Hollywood Palladium. Now, if you page down, this is of course the receiving party is First American Title Insurance, but this is deceiving. If you page up, you'll see who the real party is that's receiving these things. Page down, if you would. You want to go down, I think page, keep going, like page 4 or 5, I think it is.
Okay. All right, hold on.
Okay. Oh, what happened?
I don't know. That's what
stop
I'm
there.
trying. Yeah, hold on. It's just there's
That's
a lot.
weird.
There's a lot of hackosaurus going on right now.
Yeah, there is. Okay, I'm going to read this to you. Okay, let
Yeah.
me read it to you from my end.
Look, it won't even.
Okay, yeah, it's not showing. What this is, what's been taken out of this thing is what I highlighted. And what I highlighted is this is a deed of trust and security agreement and assignment of leases and rents and a fixture filing. Okay, now this is between First American. Now this is between again, this is between the Palladium Ventures. So this is a commercial project, okay, and it's not a residential, obviously, whatsoever. It's a Palladium venture, and they're the trustor, and First American Title Insurance Company is the trustee for the benefit of Anglo-Irish Bank Corporation, PLC. So what they've done here is this is where you got to kind of make a jump here. You got to understand that these mortgage loans that we executed are not residential mortgage loans to real property. You do not have ownership. And you'll see that when if you read the Merged Nations Bank Agreement, you'll see where we've been stripped of ownership and we've been relegated to lessors. And it tells you in the agreement anyhow that you're a tenant. And so what this agreement is, this instrument is a deed of trust and security agreement and assignment of leases and rents and fixture filing covering both the real and personal property, including fixtures, and secures future advances. This instrument contains after acquired property. What does that mean? After acquired means after they foreclose on you, after abandonment. Property provisions and secures obligations containing provisions for changes in interest rates, extensions, blah, 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 so on and so forth. What this agreement is, it's a 38-page agreement that details all of the lease payments and how the lease payments operate, who the beneficiaries are, how the obligations operate, and it describes commercial real estate, which is what they've put us into. We are not a residential mortgage loan. If we would have ownership. And the more telling thing about this is that we are instantly taken from First American Title Insurance into Allied Irish banks. We're taken right into the Commonwealth at that point in time. And that's the whole basis of this anyhow, because you've got foreign agent law firms who have no allegiance to the United States of America or its Constitution or its people. Their allegiance is to the Commonwealth. And so when we talk about federal law, we talk about the United States of America. I think what we forget to mention, we forget to take into account, is that we got 4 Commonwealth states, and of course when we won independence, we never got rid of the Commonwealth. They remained behind through the Commonwealth of Virginia and through the Commonwealth of Kentucky and Massachusetts, and what is the other one? Pennsylvania is the biggest one. And so this is what drags us back into this. Has kept us within this Admiralty Maritime Law. Are these 4 Commonwealth states? And so this is what we want to get away from. This is what all these agreements and everything in patents and trademarks is operating towards an international one world order that is controlled by British Commonwealth, by the Queen in Parliament, or as an elective dictatorship, which is exactly what we're in. And so see, all the things that people are arguing about and writing these long dissertations on is all taking place within the agreements within patents and trademarks. How can I get that to post? I'll have to send you another copy of it, Bridget, so that you can post this up, because
Yeah, I'll
It's a real
actually, no, I'll pull that link out of my Hub Docs and I'll get it all straightened away on the blog so people can access that
Okay.
link. But yeah, it's
Yeah,
not a
because
problem. I'm just having some weird hacking problems and I'm buffering, I'm buffering out the hacking as best I can. So, so,
yeah,
okay. So
okay.
anyway,
Okay, so let's see. Hopefully, it's not like this for all the agreements. If it is, then we got a problem. It's if you can open up the Irish Bank release chain of title. It did the same thing, didn't it? Why is it? Oh, there we go. There we go.
It's trying, but I don't know what it's doing. It like
Okay,
will
let's
let you look
release.
at like part of it, but it won't let you look at like all of it. It's weird, kind of weird. Look, it's like somebody
Why is
is
it?
like getting rid of the pages on the
Why
link
is
that
it?
I posted, right? And I posted it from, yeah, they don't
That's
like
weird.
us right now, Ken, at all.
I don't know. I can't explain it. That's weird.
Yeah, they're
I'll have to
watching
post
us.
these up.
They'll
Screw 'em. They'll
work
learn
once
something.
I'm not on Zoom, they're gonna work. They just
Okay,
don't,
well,
they're
how
just
can we get
blocking.
these? So if we post these to your pay or to this site, then people can go and get these documents for themselves, right?
No, I already posted the link. It's like the link will work once we're not on Zoom. We're being hacked right now because we're on Zoom, right? And you're talking
Oh,
about this stuff. So this is the kind of stuff that happens. But once they're done, because I made sure that all these documents were open and public, it's just they're not opening.
okay. So what I have to do now, I have to get with Marjorie then and have it posted to that other blog then that's not Zoom connected, right? And so people
No,
got to see these documents because this is
no, I know, but I have them.
no.
The links are good. It's just Zoom will not allow me to open the good links, right? So this has to do with Zoom because we're
Okay.
screen sharing Zoom. So the links on the blog are fine. You
Okay.
can just go there and I'll even
Okay,
double
perfect.
check. They'll be fine. It's
Oh.
just Zoom is just not cooperating. So they're blocking out some of the links. They're blocking out some of the
Gotcha.
pages,
Gotcha.
right? Yeah, because they don't want this. I mean, we're videotaping this, they don't like it. I can assure you, they don't like
Yeah,
it at all.
Well, I don't care. Tough.
I know.
Okay.
But,
Okay. Well, anyhow, let me
here
describe
it
this
goes.
agreement.
Okay, now it's coming back. Okay, so what page do you want to go on this one, Irish Bank?
Okay, yes.
Yeah.
Yes.
Which page?
Oh, wait a minute.
It's starting to show it now.
Page down. Keep going.
Okay. Now, see, then it stopped there at that page. So.
And it stops.
Yeah.
That's weird.
Yeah. No, it's being hacked. It's just, it's just how
All
this
right,
kind of stuff is.
let me explain to you what I have here. What I have here is I've got an assignment abstract of title. It's a.
Here we go. Okay, so now it's letting more up. So what are we at? Where do we go?
Oh, okay. Okay.
Is that where you want to go, patent of release?
No, that's not the document I wanted. The one I wanted was the Irish Bank release chain of title. The chain of title. This is the agreement.
Title. Okay, hold on.
I want the chain of title to show that.
I have that too.
We got to figure out a better way to convey these links so we can transfer these things a lot easier.
No, they're fine. If people go to the blog, they'll get the link. It'll be fine. It's just not happening on Zoom. And sucks because Zoom is like, being a pain in the ass, right? Because we're being hacked because they are trying to like stop the process. Because I have super fast bandwidth, I have everything going on, but my radio shows were like this too. Sometimes we couldn't even get on the radio network, and then I have to get on by the phone. So when you start getting into some of this stuff, you're going to get hacked. You're going to have a lot of stuff hacked. It's just how it is. Okay. So anyway.
So I'm going to talk about the Irish Bank release chain of title. If you can open it on your side, this is what we have. Okay, so we have 7 assignments here. If we go down to the very bottom, the very first assignment is assignment number 1. It's conveyance. The collateral assignment security agreement. Okay, now that agreement, I'll provide that agreement is 25 pages, but it's between a company called Escher Group Limited and Citizens Bank of Massachusetts. What is Massachusetts, folks? It is a what? It is a Commonwealth state. And this is a conveyance of, this is a Escher Group that's related to insurances and real property and things of that nature. You go to assignment 2. Now this was done on January 4th of 2000. On August 1st, 2001, assignment 2 was done, which is an assignment of assigner's interest. These are the agreements that they suckered us into. So you got the assigners here, which is this Eric Matoyas and Joshua R. Smith. These 2 individuals are the inventors of this, whatever property this patent represents, okay? Now, these inventors, what they're inventing is they're inventing a process, okay, that they have assigned to the Escher Group, all rights, title, and interest there too. These patents, these processes that they're signing away, we have ownership in, because what they're starting off with is a particular note, or we're the subject of these things, and they're breaking this up into different pieces, parts. And whether it be a foreclosure patent, whether it be a bond issue, whether it be a stock issue, what they've done with all these patents, as in the assigner position, we are the subject, and through this assignment of assigner's interest, they are assigning away all our rights, title, and interest to the patent, all the profits to it, and everything, by creating separately managed accounts. So we are, in effect, uninformed assigners and co-inventors of these patents. So we have rights, title, and interest in these things. So this is where they put us. They group us into this assigners here under these patents, and they assign all rights, title, and interest away to Escher Group. Then on March 24th of 2006 is a third assignment. Now this is assigners of Citizens Bank of Massachusetts to the assignee Escher Group. So they've done a reverse of assignment number 1, which was the collateral assignment. So they did a swap agreement on that. And then you go up to assignment number 4, which is a security agreement. Now this is between Escher Group and Capital Source Finance, LLC. Who's the source of the capital, guys? We are. We're the source of the capital. These are the customer lists. These are the lenders lists. These are the list of assets. These are the collateral assets and properties that are the grantors. And then you go up to assignment number 5, and this is a patent security agreement between, now they created a new company called Newco Limited. So what they've done here, in effect, is they've taken our names, they put in the customer list, they form new corporations or LLCs, and in this case, they call it Newco, like New Corporation. And of course, it's a limited, so this is going to be a British corporation through Massachusetts. And who are they assigning it to? They're assigning all these assets to Anglo-Irish Bank. And then you go up to assignment number 6. It's just the release of security interest and patents between Capital Source and the Escher Group. So what they're doing is they're going back and forth between all these entities, and they're swapping between what they'll have an assignment of corporation ABC to DEF, and then they'll go ahead and reverse this thing. And then what they'll do is they'll do another assignment where they do a merger between a corporation and an LLC, the surviving portion of the surviving company being a new LLC. So what they're doing is they're laundering all the profits through these created entities that are being created in patents and trademarks. And if you can't see it in front of you, then it's kind of hard to explain. Is it making sense what I'm saying, though? Maybe I'm not explaining it. Hopefully I'm explaining it clearly enough.
Yeah, no, you got it good.
Okay, so now the name of this invention in this particular assignment is data encoding and decoding using angular symbology. This is a very interesting patent. So what this comes down to the end of the day is this is all about data and information. It's about workflow and how they're handling information. Because what are they doing? Because there is no mortgage loan, right? There is none. There's nothing there. They're leasing. They're borrowing our collateral value, the value of our name, the credit behind our name, the energy of that all capitalized name, and they're controlling that name. And by doing so, they're controlling all the profits. They're controlling every aspect of this. because they've taken it into their private, if you want to, I don't really consider it private, but they've taken it into the undisclosed patents and undisclosed trademarks, making us think that we're a debtor. We're not a debtor. This is the importance of getting rid of those intermediaries by filing into patents and trademarks. By claiming that name, we get rid of all these intermediaries that Thomas was talking about in Florida and everywhere else. You've got the intermediaries that are controlling us. Where does it stem from? It all stems from patents and trademarks through these agreements in here. And so you have, oh, it came up on yours finally.
It's been up for a while.
Oh, I didn't know that. Okay.
It just depends on the document right now. It's like right now it's showing this whole document, you know, and the other one it didn't like at all. So, but it's all
now,
good.
can you put, are you able to pull up the Escher patent collateral assignment?
Let me look. One moment, please. No, I'm just kidding. All right, so it's
Yes, they're playing hide the banana. That's exactly what they're doing, Thomas. They're doing exactly that. That's exactly what they're doing. What they've done here, in a nutshell, what they've done here, what you got to realize is the action is not within the court system. It is not within the Secretary of State. All of the action is within patents and trademarks. This is where they're playing hide. You're exactly right. They're hiding the banana, and they're hiding the fact. They've hidden from us that the whole economic and financial system, as we knew it was scrapped. They threw it out. They trashed it, but they made us believe that it's still business as usual. What was put in its place? What was put in its place was all these patented processes, all these different kinds, and we'll go through the particulars of these patents, of the actual processes next week. But what these are is, these are loan origination, creating of bonds, separation from your accounts, foreclosure patents, all these different, anything you could possibly think of is what they're doing, okay? And it is playing, and they're hiding the banana. What they've done is they've stolen our identity, they've pulled it into offshore accounts through patents and trademarks and the agreements underneath that, and they've made us believe and well, put us out there as being the debtors. And so they control I'm sorry, what?
And they're also avoiding the potential liability under 15 U.S.C. 1 and 2, which the liability is $100 million per corporation and $1 million for individual, let alone the damages under Title 42, 1983, which then coincides with Title 18, Section 242, which is the criminal side of it.
Now, see, now you're right, and now that you've corrected your, I don't like using this phrase, but now that you've corrected your status, which is essentially what you're doing here, by filing into patents and trademarks, what you're doing is you're correcting your status, and you're correcting it at the very point of origin, where all this stuff stems from. Now what have you done? Now you've stripped them of their immunities. Now you have the power and authority, because it's in the agreements that you have the right to sue for past, present, and future infringements. Now you have the standing to do what you want to do, Thomas. Go after these guys and sue them in court if you need to do that, if you want to do that.
So where do you want me to go on this document?
Just page down through the document. This is a very detailed document.
To where? Just
page down to where the beginning of it is, so we'll tell what it is, what the document is. Keep going. Oh, it's doing it again.
I know.
Why is it
weird,
doing that? I know it's hacked. It's being hacked.
It is.
What this agreement is,
blocking
if you
it
could
out.
pull it up,
Oh, here.
if you could pull it up, you got it?
It might adjust. Sort of trying to adjust, but there's just a battle. So go where?
Well, if you, I gotta come back to you. It's not coming up.
It's just downloading. It's a lot of material. It's a lot of data.
No, it's not downloading. It's actually blocking out pieces.
Yeah, it is blocking out pieces because it's not a huge document.
No, they're not very big documents, so it's blocking it out. And I have a lot of, like I said, I have a ton of bandwidth, so I'm good. So let's see what we have here. Okay, so
stop right there. Okay, it's a patent collateral security, a patent collateral assignment security agreement. Okay, now this is between the Escher Group, which we see is connected to Irish Allied Bank. This is a revolving credit and term loan. If you read this agreement here, it doesn't really define who the actual lender or borrower is. Really, it's kind of like a group of lenders, and that are participating in a revolving credit and term loan agreement. So what this, if you read this agreement, I'm not going to go through the details of it because it's a pretty detailed agreement. You can read it for yourself. You can see what they're talking about here. We're the assigner. We're the assigner by uninformed consent. The impersonators have taken charge of our name and our signature and attaching us to these things, these patents and these agreements they're under as the assigner. And the assigner is the one that is, oh yeah, I'm going to give everything away, hunky-dory. I'm going to give it to the attorney. But what's important to do here, what's important about this agreement, it's in the second whereas, where it says, whereas it is a condition precedent to the banks making any loans or otherwise extending credit to the assigner, which is us, under the credit agreement, that the assigner, that's us, execute and deliver to the agent for the benefit of the banks and the agent. Patent agreement, substantive form hereof. And then it goes on to defines all the terms and conditions of everything that we've given over to the agent. So what we've done is this nominated agent, we've given all rights, title, and interest over to an attorney who is the agent, who is in collusion with the banks, which is interesting because you've got the banks that should be held to account legally, but they're being protected, aren't they? By who? The foreign agent law firms who don't have any allegiance to this country whatsoever, or the Constitution, or the people they're under, but yet they're controlling the court system. They're controlling the whole legal system by these patents and trademarks. It's very clearly defined in here that this country has been taken over, has been conquered by coup d'etat, essentially, by foreign agent law firms in collusion with the business of banking. It should be very clear within this. I think that's a huge, huge point.
This is evidence of the violations of the Hobbs Act and extortion and robbery under 18 U.S.C. 1951.
It's sedition. It's sedition too. It's sedition. Yep. Wouldn't you agree? It's sedition is what it is.
It's sedition and treason. Yep.
Yes. It is, and see now the beauty part. See, so you got to realize what we got to do is we got to focus to the hub of this stuff. And I'm hoping that Thomas sees it. I'm hoping everybody else is starting to see how this all comes together, and it really does all come onto a central hub system. And everything that emanates out of this thing, all the shit that they're pulling in each individual state. These law firms, these foreclosure mills, even government, where are they drawing their powers from? Where are they getting it from? They're getting it from these agreements and patents and trademarks. That's why we've got to go to the source and cut them off at that point in time.
Well, they're operating in law, and when we hire an attorney, they're at law. So there's a separation right there, uniquely designed to separate it. So when you're in,
all right. So.
Well, he brings up an important point. Obviously, he's right there. Let's talk about that for a minute, because what we're talking about here, in order for us, they talk about natural person. They define us as a natural person. Well, what is a natural person in this context? It's really just a body of living matter that's been separated from its form. What is its form? The form is the all capitalized name, which we can call the soul. Okay. So what we got to do? So we've got body and soul, matter and form that have been separated by these intermediaries. And so that's a real important point, because that's what we've got to take care of here. And so we have to have there's nobody that can help us but us. There's nobody that can come in. We can't hire an attorney. You have to close it out of the water. We have to do for ourselves, because how else can we be an individual personality? That's what we want to be. We want to be an individual personality. You can't be an individual personality if you're a natural person, can you? Because you got these intermediaries in between you, which are agents, attorneys, and all these secret agreements. So how do you get rid of those things? You go to the source and you say, hello, I'm Kenneth W. Dost, the natural person, otherwise known as a body of living matter, and that all capitalized name is mine. It wouldn't exist if I didn't give it first breath. That's mine, and I've taken claim to that. And by doing that, I'm getting rid of all these intermediaries. By virtue of this filing, I'm doing that. And that's the beauty part about this.
Title 20.
They have no defense, do they?
Right. So it's 5:35. I mean 5:33. So what do you want to close with, Ken?
Well, since these agreements are kind of coming up as they're coming up, you got them posted to your page.
I do.
This is not. Let's kind of wrap it up here. But let me just say that this is complicated. It's hard to understand. It is. The basis for it is those first two Zooms that we did, that we talked about the name. It's real important to capture all that and understand that. And I understand what Thomas is doing. I appreciate what he's putting up there as far as all the codes are concerned. But really, if you think about this, we could push all that aside, really, and take care of it, and just simply take care of it by making the correction with the patents and trademarks. It clearly shows that there's violations there. constitutional rights have been violated by deceptive trade practices, and they've been violated by whom? By foreign agents who have no business representing us, but yet we're hiring them to represent us. They run our legal system. They've corrupted our courts. So we've got to go. So the whole point of this is to come to patents and trademarks. No, it is complicated to understand. It's hard for a lot of people to wrap their mind around the fact that this all capitalized name, first of all, is anything but a fiction. And it may be a fiction in relative terms, but if it was a fiction, it wouldn't affect my life or it wouldn't affect your lives. And albeit all these patented processes, what are they? They are fictions because they're made up processes by from somebody's mind, but they've affected our lives and they're running our lives. And when you're standing in patents and trademarks and you start reading some of these patents, the first thing you start to notice is like, wait a second here. Why are they bouncing jurisdictions? Why are they going from Mexico up to Canada, down to the United States? Why are they bouncing all these jurisdictions? Well, right there, that should tell you that all law is arbitrary, but that yet you have the nerve to come forward in the public as a legal representative for codes and legal codes and statutes. That's freaking treason, for God's sake. There is no law. And the beauty part about standing within patents and trademarks and standing on that is, what can they say to that? How can they defend it? They can't defend it.
Well, once you go into the Patent and Trademark Office and you disclose all this stuff, there's now an obligation for a private attorney general to come in under qui tam action and exercise the right and call for a full investigation under a remonstrance or a memorial in the federal House of Representatives to go ahead and start an investigation pursuant to the Jefferson Rules of Legislative Procedure. Thank you.
But we don't even have to do that though. It's per trademarks own conditions, their own regulations, that it automatically has to be a full investigative audit by Treasury, which is exactly what we want. And yes, you're right. You could throw all those other laws in on top of that to beef it up some. But the way I look at it, you got them at this point in time. There's not much that they can do because you've clearly got them on constitutional violations. Why? Because you're coming in your natural person. You're not going through any representative, you're not going through any state laws, you're not going through any other secondary laws, let's call them. You're going right to the source of things. This is one nation under God. This is how this nation was created. And man-made law has separated my body from my soul, my form from my matter. Now it is your obligation, because I've shown you prima facie that patents and trademarks is a rigged game by foreign agents who have no allegiance to this Constitution, the people, or anybody there to but the British Commonwealth. So right there, you have an obligation to heal that separation, because this is one nation under God.
Well, when you look at when you look at the Mason's Manual under the section where it says the 10 principles for group decision making, in item number 9 there, it states clearly, there must be no fraud, trickery, or deception resulting in injury. As in other situations, yes, the person is liable for damages or injury intentionally or negligently caused to another. Period. It says it right there.
Yeah. It says it right there. And it also says it right in patents and trademarks. In trademarks, they violated by not disclosing the MERS that MERS was a registered service mark. They have deceived us. They've intentionally deceived us for our own demise and our public demise, because we've been shamed publicly, have we not? We've been shamed when now this is where they transfer our name from an unregistered trade name to the common law trademark. This is where they call us out, what they call domesticating us. They're domesticating us by filing action against us.
Okay,
so what have they done? Hold on a second. They're defaming our character and credibility, are they not?
Yes.
Yes.
Yeah.
Bridget.
Okay, so what's on the brew for next week? What are we going to be looking at next week? And then
the individual process
end
of patents.
the class.
And what we're going to talk about patents and show how we're are put in as articles of manufacture, how we are constantly being remanufactured time over again. We'll see this by patents, and we'll see this we'll start Chinese chains of title together. We'll tie together like Countrywide, and we'll follow the chain of title and see that this has nothing to do with real property. It has to do with gold. It has to do with clothing. It has to do with oil and gas industry. It has to do with everything but real property. And that's the important. When you see that part about it, then you're going to say, oh, wait a second here. I'm funding everything. So that's what we're going to talk about next week. And then we'll tie it in all, of course, with the birth certificate. Because that certificate of birth, is what put us into under the Paris Convention, where we're hijacked by the British Commonwealth. And by doing this, what are we doing? We're breaking that union between England and Wales, England and Ireland that they're keeping us in, and we're putting ourselves together as an independent individual personality.
Okay,
Beautiful.
so you know, the other thing too is, like we talked about, that, you know, if we make it, because there's so much information, we make it to the 4th class and we didn't get everything done, that I told Ken that we would, you know, do a couple more classes just to make sure that we get everything in there. So, you know, 4 might not be the end, but we'll see how it goes.
No, it won't be. It won't be. It won't be, Bridget. I mean, we've got to figure out a way. Well, because there is so much information, you know, and there really is a lot of information.
If
you understand that, hold on a second, Todd. If you understand the trade name thing and the value of a trade name, then we got to start following a chain of title. And then by your own natural, by playing around with these links, I'll show you how to do it. You'll learn on your own. It'll like my friend Sandy Smith. You know, I showed her how to do this thing, and she's like, damn, this is addictive, because it is addictive, because you find out how blatant the system is, and you just follow these chains of title. The chains of title are everywhere, and that's your proof of all the crimes that are being committed.
Yeah.
So there is a lot of information, though, and I realize it's difficult to understand.
And so this is the other, so I have to get going, because I have something after this, and it's, you know, and so I just want to bring it to like the end so that we can move on.
If I may real quick, under section 35 of Mason Manual, it states, the common law of parliamentary procedure is founded upon well-established and reasonable usage. It does not rest upon mere custom, but upon reasonable and equitable custom. What is not reasonable is not law. May be said with reference to the common law of the order and the deliberative bodies, as well as to the common law of the land. Then in section 7, it states, constitutional provisions stand on a higher plane than statutes and are mandatory. Thank you so much.
Great. All right, so everybody.
And one final note. Every single mortgage foreclosure must go through the Southern District of Manhattan, where there must be submitted patents or trademarks and copyrights. Why Manhattan? Beeline to the where?
American
England.
Depository Receipt, New York Mellon.
Yep. The end.
All right, everybody. Have a great day, and we'll see you next